I'm Stephen Gold, the author of The Return of Breaking Law. There's no such thing as a free lunch.
Or a free court case.
Well, actually, there is. Running the courts costs money. That's why there's a fee which most people have to pay for starting a case and taking various steps in it once it's been started. Money goes towards those running costs, including the leaking roofs and the paralysed lifts in some courts.
What sort of fees are we talking about?
Well, I give you a couple of examples. To start a money claim in the county court, if it's no more than £300, the fee will be £35. Between £5,000 and £10,000, the fee is £455. Claim more than £200,000 and it costs you £10,000. And to start a divorce or civil partnership dissolution case, you'd have to shell out a fee of £593. With the civil court fees, if you win, the loser will usually be ordered to pay those fees back to you.
And if you can't afford to pay?
Patient, Mr. Link. There is a help with fees scheme, which may excuse you from having to pay those fees or reduce what you do have to pay. Not because you've got a pretty face, or strong case, or pathetic case, but because you haven't got the loot. And the news is that the scheme is changing big time.
Changing when?
Well, that's in fact on the 27th of November 2023. And it may save you money to get in a help with fees application to the court before that date. And it may pay others to wait and get in their request on or after the 27th of November 2023. I'll explain who would be better off moving fast and who would be better off holding on. But first, let me make it clear that we're here talking not only about court fees, that's county court, high court, family court, Supreme Court, and sometimes the magistrates' court. We're also talking about probate fees, court of protection fees, gender recognition panel fees, and first-tier property tribunals. You don't have to pay, incidentally, a fee to start an employment tribunal claim these days. To qualify for help with fees, both your capital and your income must be limited. These are the changes. Not too much capital then. That's savings and investments. If you've too much, you won't get help, whatever the amount of your income. Those most in need will be better off and so should wait if they can. The higher the fee, the more capital you can have. For the lowest fees, that's fees of up to £1,420, you can currently have capital of up to £3,000. That's rising to £4,250. After that, for a fee of up to £5,000 under the changes, you can have capital of up to 3 times the amount of the fee. For a fee of over £5,000, you can have capital of up to £16,000. When it comes to a litigant aged at 66 or more, you may benefit from waiting because you'll be able to have savings and investments of up to £16,000 even for small fees. Currently, you have to be age 61 or more to score there. The qualifying age is going up from 61 to 66 to align with the current state pension age. Next, income. The changes are more generous to the most in need. That's principally because you'll be allowed to have a higher gross monthly income than as at present in order to qualify. For example, if you're a single person, you can have an extra £250 a month. That's up to £1,420. A couple can have an extra £535 a month. The allowances for children also increase. And if your income is variable, it can be averaged out over 3 months before your help with fees application, if that would bring it down. Anyone on means-tested benefits will automatically pass the income test. So, if you would fail on income on current figures but would pass on the higher figures, wait if you can until the 27th of November to put in your application. I advisedly say if you can, as you won't be able to apply for help before you actually start the case. There are strict time limits for bringing civil claims. Don't hang on, if that would result in your time for bringing proceedings running out.
When might you have to pay something towards the fee?
Well, there's a change here, so you could find yourself worse off by waiting. The more you earn above the income threshold, the more you'll have to pay towards the fee. At the moment, you will qualify for partial help if your gross monthly income is no more than £4,000. From the 27th of November, that figure's coming down to £3,000 a month. You could qualify for partial help now, but not under the new regime. In that event, apply now if you can. A fresh application for help with fees has to be made each time a step is taken in proceedings that generates a fee. You may be financially out of the scheme when the case starts, but within it when another fee later becomes payable. And if you've already started the case and had to fork out for a fee from your own pocket, you can apply for help when later fees become payable. If you can bear it, you will find chapter and verse in the Courts and Tribunals (bracket) Fee Remissions and Miscellaneous Amendments (close brackets) Order 2023, that's Statutory Instrument 2023/1094. But you might find banging your head against a brick wall for half an hour more satisfying. If you have a solicitor acting for you and a fee is coming up, have a word with them about timing. Apply for help now or on or after the 27th of November. That is the question. Keep abreast of the latest legal news on my blog. You can reach it at breakinglaw.co.uk. And if you sign up for alerts of my latest posts, not only will my publisher think I'm more popular than I actually am, but you'll be able to order a copy of my book, The Return of Breaking Law, and probably save a couple of quid on the price.